This is Laws 13017, Civil Procedure, Week 10 Trial, and tutorial problems 27 through to 29. Okay, so far so good. I've spent most of this week reprogramming the quiz, because the quiz in the past had negative marking in it, so that, for example, if you had to select 3 answers within one question to get it correct, then you would get 1/3 of the mark for each selection. But if you selected something that was wrong, you would lose 1/3 of the mark. The reason for that was to ensure that people just didn't fill in everything and get 100%, because that's how the quizzes with Moodle are designed. So what I've done now is I've reprogrammed it so that the way it's set out is that it has the question. So it might say something along, and I gave you some lead-in phrases for some of those questions during the week. So it might ask you which 3 of the following satisfy, answer the question. And then what I've done is I've put A might be, or the first choice might be ABC, second choice might be BCD. So you'll be given 3 options, and there'll be 6 of those sets of 3 options, and you can select the one that's correct. And if you don't select the one that's correct, there's no negative marking. You just don't get the mark for that question. Okay, so I've redesigned it that way because people get terribly afraid of negative marking, whereas in fact, it's not a bad outcome, because if you actually know 2/3 of the answer, but not all of it, you get 2/3 of the mark. But the other way, if you don't know the answer, you don't get any mark. So it's yin yang, really. But anyway, so I've got it so that you can now make your selection, and of course you can guess if you want as well, because there's no downside with guessing, because there's no negative marking. Anyway, so that's that took me a few days this week to sort that out. All right. So what we're up to this week is looking at trial. So the first problem we've got is a trial may take place at any time after the close of pleadings. Okay. Defendants can apply to have a case struck out for want of prosecution if the trial is not entered in a reasonable time frame. And then you're asked, when should a trial occur to achieve justice between the parties? Okay, so there have been situations, for example, in the commercial, what used to be called commercial causes list, where something has gone to trial within a week. So it is very rare, but that such a thing can happen. But typically trials are a long way in the future. So what do you think the general answer is to when should a trial occur to achieve justice between the parties?
Is it when the pleadings have closed?
Definitely, yep. Pleadings are closed.
All the witnesses are available and discovery is complete.
That's right. And all of the pleadings are settled. There's basically all the interlocutory processes have finished. Now, there are causes for delay. So what might be some of the causes for delay in delaying the trial? Any suggestions? Well, it takes a lot of effort to actually prepare for trial. So you've got to prepare a brief. If you're the solicitor, you've got to prepare a brief to counsel. The counsel has to talk to all of the witnesses. As a solicitor, you probably will be taking witness statements as well. So all of that needs to be done. It takes quite a bit of time. There may be a lack of information in some respects. And even the disclosure process is giving you a pile of documents. And, they're not necessarily in any linked order, in the sense it might just be a list, 1 to however many, and it just has the documents described. It doesn't tell you how the documents interrelate with each other. So that takes time to analyze all of that and to prepare your brief for counsel. Some of your brief for counsel probably involves you collecting relevant cases and perhaps giving some opinions on which ones would be the ones that are most likely to be used in the case. all of that takes time. Law firms are busy places. They won't just have one thing going on. So, staff can be committed on a number of matters. You may have some staff that aren't competent enough to do that and require supervision to build their skills. So all of those things can cause delay. Another form of delay is with scheduling. Courts have to schedule the trials, and it depends on the number of judges that are available at any particular time. And it's quite common for courts to schedule up to 3 times as many matters on a particular day than will actually proceed to trial. And the reason they do that is because things settle. So they don't want to have a situation where judges are sitting there with nothing to do. So they will often schedule up to 3 times as many things on the basis that 2 will settle. Because when you come up to trial, that's a real pressure point. If you avoid the trial, you save a lot of costs. You're not paying the refresher fees for the barristers on every single day that the case is being argued. So there's a lot of settlement that happens on the door of the court leading up to the trial. So all of those factors are delay type factors. All right. Now let's have a look at the actual procedure. Now all of this is set out in a couple of places in the rules, but there's also a practice direction, number 9 of 2010, which you need to have a look at. And that particular practice direction is about setting trial dates for the civil jurisdiction in Brisbane. So essentially what happens is that there is all the parties sign a request for a trial date. So there's a Form 48 that does that. So one party will prepare that and submit it to the other parties, who then determine whether they're going to sign it or not. Once it's been signed and it's filed, then what will happen is that the registrar will then set a trial date in sittings that are coming up in the future. Now, one of the conditions that you need to be satisfied before you sign that it's ready for trial is in Rule 469. So it's a readiness. Basically, it's a form of readiness. So you've got to signify what was mentioned before. The pleadings are finalised. No further particulars are going to be asked for. All the necessary witnesses are available. There's no point in having a trial if the witnesses aren't available. So they've got to be available. If there's subpoenas that they've been issued, and that, that's one aspect of witnesses being available, and that there's nothing which would prevent the trial from proceeding. Now, it is possible for one of the parties to refuse, and then it might go before a judge and a determination made as to why there's delay. But ultimately, a trial date, there'll be sittings of, usually sittings can be up, a week up to 3 weeks of sittings for a particular group of judges, because the way in which the court works is that judges are out, their overall time is allocated to different sittings and they rotate. So for example, they will say Judge A has got 3 weeks of civil matters, followed by 3 weeks of trial, followed by 3 weeks on circuit up north somewhere, followed by whatever. So there's a group of days that judge is available for to hear particular types of matters. So there's a 3-week period for a judge. There will be a 3-week sitting in effect. So what you'll be doing is you'll be allocated a date within that sittings. And what they usually do is they have a call over of the matters for that sitting. So a judge will run a call over and they will work out the order in which the actual cases will be heard. And if something settles, then of course you're obliged to tell that judge that a matter's settled, and then they take it off the list. And then eventually you'll be allocated a specific day, and that's when it'll proceed. You'll be allocated a day at a courtroom. It'll get on the court list, which they publish, and it'll say, the matter of A versus B before Judge X in courtroom number 5 on this date starting at 10 o'clock in the morning. And that's how it all progresses. And then it's just heard. Now, it is possible to get an expedited trial, like I mentioned earlier, with a commercial causes matter that is really urgent for some reason. So Rule 468 enables that possibility because some things are ultra urgent. But if we actually have a look at the practice direction, I'll make this a bit bigger. Share screen is hidden. Now let's see. So hopefully you can see that if I make it a bit bigger. Is that coming up okay? Can you see that? Does that come through?
Yep.
Yes,
Yep.
thank you.
Okay. Sorry, I'm a bit uncertain about this because it's not the normal way I operate. But anyway. Okay, so this is the practice direction. So just having a quick look at it, you'll need to spend a little bit of time going through this. But you can see here, although it's quite an old practice direction, it's still current. And it can be done electronically as well. So you can see here, it's talking about in the third part here, filing a Form 48, the request for a trial date. Or alternatively, you can have an order of a court to get there. So that's if, for example, you've got a really expedited matter that has to be dealt with, you get a court order to do that. And it also talks about supervised case lists and commercial lists, which are some of the other lists that are available. We've generally not talked about those. We've focused on the stock standard type civil matter rather than these specialised lists. All right, so anyway, the request for trial date is filed. And you can see here it talks about a readiness checklist. So if we can just go skip down there for a minute, you can see the sorts of things that are in the readiness checklist, the things we mentioned earlier. Pleadings are in final form, don't need amendment. Disclosure has happened. Any interlocutory processes, particulars have been finalised. Interrogatories have been answered, etc. All the witnesses are available. That sort of goes on and on. So there you go. So that's basically what when you say it's ready, that's what you're signing up with, that you've checked through this checklist. And then what happens, we go back up here again. So essentially then you're allocated a trial date. So there'll be a list manager. Sometimes, well, historically that would have been a judge. They may have senior judge administrator might be somebody who does that as well. So it basically just continues on like I mentioned before. So everything I've said before is really repeated in this practice direction as to how it all works. There's a few things there, I suppose. After the review, allocation of trial dates, something may have happened. So you can see, because things do happen. So can a party, for example, try and vacate a trial date? Well, they can't do that by consent. The parties can't agree with one another to vacate a trial date. Could you imagine it? Create chaos because the courts are assuming their matter is going to proceed. They don't want them parties by agreement wrecking the list because it's hard enough to manage by itself. Contested applications for amendments or respective disclosures should be done in the applications jurisdiction rather than at trial. So what that's saying is that if for some reason there needs to be another interlocutory application, you can't make that at the trial. The trial is supposed to be resolving the issues. The interlocutory procedures should have finished. So you can't keep that up your sleeve and then run that at the beginning of the trial. That should already have been sorted out. This is important here, this one about the time allocated, because you're supposed to give an estimate of how long the trial is going to take. So you will do that in consultation with your barrister. But if it turns out for one reason or another that it's going to be less or more often longer, then you need to advise the civil list manager about that, because it affects the number of trials that can be heard within that sittings. and it may result in some cases being pushed over into later sittings. And remember, there's a lot of inconvenience. Witnesses are supposed to be available on those dates, and if you've got especially expert witnesses, they have specific times that they're available. They can't just drop everything they're doing and make up different days. So there's limits on those sorts of people's time. The matter settles. Obviously, the list manager needs to know about that. There's going to be an adjournment. They need to know about that, etc. There's a little catch 7.6 there. All the fees have to be paid. Filing, hearing, and other fees have been paid before the trial commences. Yep. So that's basically what the process is. All right. That's that question, really. Any questions about those aspects of the trial? The mechanics of how you actually get into court? No? All right. Problem 28. Discuss whether a civil jury still has a role to play in the Queensland justice system. Okay. So how many civil jurors are there?
4.
There's 4. Okay. Here's a trick question. How many civil jurors would there be if it was a case involving personal injuries?
0.
0. Why?
Well, I think there's a statutory provision that personal injuries is heard by a judge.
That's right.
Alone.
Exactly. So the Civil Liability Act, Section 73, says that in relation to torts involving personal injuries, that has to be dealt with by a judge sitting alone without a jury. So there are quirky little provisions around that have impacts like that. But generally, you're looking at a civil jury consisting of 4 people. So it's impaneled in the same sort of way that a criminal jury would be impaneled, so that there would be, a whole pile of people would be make up a jury panel, and then, there could be objections about them, but ultimately you settle down to 4. All right. So, by the way, it's Section 32 of the Jury Act, is 1995, is the section that says it's 4 jurors, civil jurors.
Stephen, may I just take the question one step further? When you ask why there's a provision for no jurors on personal injuries, what is the reason for that?
I think the reason, there's several reasons. One reason is that there's probably going to be expert medical reports. So that involves potentially having to come to grips with complex reports. So that's one reason against it. Plus, I think they're trying to take the emotive side out of those sorts of cases. Really, the only sorts of cases where you see civil juries are usually defamation cases. That seems to be pretty much the sole area that you see them in.
I think there's a tendency with a civil jury where they might be going up against a corporation to want to have their pound of flesh out of the...
Especially if it's an insurance company.
Yes.
Yes, which is going to be often with a tort matter with civil liability act, is often going to be some sort of insurance company involved, and the complexity of it. So I think that's what they're trying to see. The other thing, juries are very unpredictable creatures, so you're generally pretty brave to go with a jury, I think. But anyway, you're not allowed to by the Civil Liability Act, which was all designed to try and reduce the cost of litigation in relation to personal injuries. So if you had a jury, then potentially the trial could go longer, more expensive, more court time. So I think that's some of the underlying reasons for it. All right. There is a right to elect for a jury trial, except where you're prevented by legislation such as with the Civil Liability Act. So that's in Rule 472. So it's a qualified right. So the court can order or may order a trial by judge alone if the case is complex. And that's written in the Jury Act itself in section 65A. And it basically says a court may order a civil trial without a jury if the trial requires a prolonged examination of records or involves any technical, scientific, or other issues that cannot be conveniently considered and resolved by a jury. So basically what they're trying to do is eliminate anything that's complex out of the equation, so that you don't have a jury considering that, because they, juries, put it this way, judges are used to this sort of stuff. That's what they do all the time. They're constantly reading technical reports, listening to the evidence and making decisions about it. Whereas a jury, it's not something that they would commonly do. So you get a mixture of types of people on jury. Some of them might be able to deal with that, others don't, don't have the ability to understand it. So that's why they try to avoid it with any of these complex cases. All right. Now, it is possible for a court to order a jury trial, even in categories where the parties don't actually have a right to opt for a trial by jury. So Rule 475 allows for that, but that's rarely going to be ever used. Very rarely used. So generally juries are avoided. There's also a lot of statutory provisions. We've mentioned one, the Civil Liability Act, but there's a whole lot of other statutes that restrict the right to have a trial by jury. And a lot of them came about in 2001. It was all around things like, well, an example would be the Occupational Therapist Registration Act, Commissioner for Children and Young People and Child Guardian Act, Health Practitioners Professional Standards Act. A whole lot of acts preclude a right to trial by jury. So basically they're limiting the ability to have juries. All right. Let's see. And there was actually that recent case I mentioned too in Victoria, that they were removing the right to trial by jury with respect to the implications of COVID, because you didn't want to have juries sitting together. So when a judge refused a request for trial by jury, that went on appeal, and it was held that that was a valid decision not to have a trial by jury in those circumstances because of the impact of COVID. And there's been other examples of this in history as well. During the war, they restricted Second World War, they restricted rights to trial by jury as well. So it's not unprecedented, but the actual right to a jury goes back, 500 years in England. It's long part of our legal tradition to have the ability to have a jury. But really where we are in Australia is you only really see it in defamation type proceedings, where something typically has been published in a newspaper, and that it's relatively simple, and that a jury can make a determination as to the effect of that on a person's reputation. So that's typically the sort of circumstances. And I'll in the answer guide I'll give you, there's a few cases that outline those sort of situations, and also there's a case there that outlines the history of it, and that's Gerlach's case, Gerlach and Clifton Bricks Proprietary Limited. It's a High Court case. It sets out the entire history of the right to have a jury, but these days fairly limited. I won't go through those cases. So I'm a bit conscious of this storm. Might actually end our session early, but we'll keep going. All right. Okay. Problem 29. Discuss the likely outcome in the following situations. Okay. The plaintiff attends the trial, but the defendant does not. Okay. So, things happen. Sometimes parties don't turn up, believe it or not. Sometimes neither party turns up. So let's look at it. Look at the situation where the defendant doesn't turn up. What does the plaintiff do? Any suggestions? What does the plaintiff do?
Plaintiff must still prove their case under Rule 476. You're on mute, Stephen.
Stephen, we've lost your sound.
So that's quite correct, sorry. 476. So default of attendance. So what happens is that if a defendant doesn't appear when the trial starts, the plaintiff may call evidence to establish they're entitled to judgment against the defendant as the court directs. Now, it's quite possible that there might be an adjournment. That's provided for in Rule 477. So the judge could adjourn, or equally likely, the judge may allow the plaintiff to prove their case and get a judgment. So the moral of the story is don't be late. That's not the day to be late for court, is when you've got a trial, because there's these adverse outcomes. What about if the plaintiff doesn't turn up, but the defendant does?
The defendant.
Sorry, Natalie, you go.
The defendant is entitled to dismissal of the plaintiff's claim under the same rule, but in Part 2.
Yes, and what if they have a counterclaim?
Would they proceed to prove it?
Yeah, so they're effectively in the position of the plaintiff, so they can then proceed to prove the counterclaim and get judgment on that. It's also possible it could be adjourned as well. So that's basically the outcome. What if no one turns up? If no one turns up? Then it's conceivable that this could happen, but I don't think it's very common. Well, what do you think could happen?
It would be dismissed, wouldn't it?
It could be dismissed. It could go on what they call the abeyance list, or it could just be adjourned. So the abeyance, you never want to be on the abeyance list. It's basically no man's land, and it just sits there, and then you've got to actually get yourself off that list and reinstitute the proceedings to actually resolve the matter. But the judge would probably be quite happy in the sense that they would have a free morning or something. Or they could be allocated. I mean, I've seen situations where they've been allocated to, say, their trial has suddenly disappeared. And if there's no other trial that's actually ready to proceed, then the judge either gets some free time to go and write some judgments, or they get stuck on, or they get reallocated to chambers to assist the chamber judge to deal with the chamber applications. But that's, it's pretty rare for something like that to happen, because usually people will be represented. It'd be a pretty brave solicitor or barrister who fails to turn up. I suppose it's more likely or possible if they're self-represented litigants, but it could be dismissed, it could be adjourned, or it could be ultimately put on this abeyance list. So it's not an outcome. It's not an outcome you really want to have.
Could you not be issued with a fine if nobody turns up for wasting the court's time?
I don't think so. It's not it's not regarded, for example, like a contempt of court. They're not going to issue a bench warrant or to arrest you or anything. They'll it's more likely to either be adjourned or dismissed. So no, they won't issue a fine. No. All right, the last little bit. The general power to set aside default judgments. Where do we find that? Anybody know? Default of attendance. So if you have a look at 476, it says the court may set aside, subrule 4, 476 subrule 4 says the court may set aside or vary any judgment or order obtained because of subrule 1, which is if a defendant doesn't appear on the terms that the court considers appropriate. So if in subrule 1 the defendant does not appear when the trial starts, the plaintiff may call evidence to establish an entitlement to judgment against the defendant the way the court directs. So you can have that set aside, and there's also the inherent jurisdiction as well. The court can exercise to prevent abuse of its own processes. So they can set aside default judgments. There's a lot of flexibility in the rules. So that is it. Did you want to have a look at one of the appeal questions? So I think I've given you the answers to these ones because we've got a bit of time. So we've gone quite quickly through these ones, or we could have a look at some of the jury cases if you want to. What would you like to do?
How about the appeal? Is that on the exam?
On the
Shouldn't they?
exam, there are questions on
For each
appeal.
week, so we should
Appeal a
maybe
new
do-
trial.
maybe
We can have a
do
look.
appeal.
We can have a look at problem 30 if you want. So that's about a fund, the appeal cost fund. So we'll have a look at problem 30 then. It says, imagine you're junior counsel at the Inns of Court, Brisbane. You've just been given your first brief. The solicitor has been involved in a lengthy Supreme Court action concerning breach of contract and a claim for specific performance of an agreement between herself and a former business partner, Simpkins. Anyway, in the court of first instance, Samantha, who was the solicitor, was successful. It's really beginning to rumble now. Simpkins appealed successfully to the Queensland Court of Appeal, and your brief instructs you that the appeal was successful upon the following two grounds. The court of first instance, when construing the agreement between Samantha and Simpkins, erred in the interpretation of the terms of the contract. Okay, so there's been an error by the court in terms of the interpretation of the contract. The court of first instance failed to determine whether a term was a condition or a warranty. So it's really an error of law. Okay, so the judge at first instance has made an error of law. Suancy believed that their client may be entitled to be indemnified for her costs from a public fund, but this will involve making an application to the court, and you're instructed to prepare an opinion on these issues, the existence of the fund. Well, there is a fund. It's called the Appeal Cost Fund, set up by an act, the Appeal Cost Fund Act 1973, Section 15. There's also a practice direction, number 3 of 2013, that deals with this as well. But you're only going to get a relatively small amount of money. I think the maximum is something like $15,000, and your appeal is going to cost more than that. But it's only in very limited types of circumstances where you'll be able to get access to this fund. And the way in which the fund is set up is, you remember when, if you did the assignment and did the magistrate's court side of it, you would have had the actual filing fee listed, included a small amount of money for an appeal cost fund. So it's funded out of the filing of the originating claim, in effect. Okay, and so it produces this fund. But the eligibility requirements are set out in Section 4 of the Appeal Cost Fund Act. So basically, it has various sorts of limitations. Hang on, I've got to let my dog in. It's scratching at the door. Hang on. Sorry about that. It's the trouble with the storms. It makes my dog want to sit under my chair. So there you go. All right, so the Act defines appeals. So it does include things like orders for review, case stated. So in our particular example, it's a normal appeal, so that would be covered. It defines what a court is, and that can include, it's quite broad, it can include a board or any body or person from whom a decision leads to an appeal to a superior court on a question of law. So that could include magistrates' court decisions, could include district court, could include Supreme Court, and other sorts of boards and bodies that are around where they have particular acts that enable them to have these sorts of appeals. Now, the appeal has to be on a question of law or an error related to a question of law, which is what we have on our facts. So section 15.1 talks about an indemnity certificate and says where an appeal against a decision of a court to the Supreme Court, to the High Court of Australia from a decision of the Supreme Court, so it extends even further up the chain, on a question of law succeeds, okay, which is what happened on our facts. Remember that the appeal was successful. The Supreme Court may it's discretionary, may upon application made in that behalf grant to any respondent to the appeal and an indemnity certificate in respect of the appeal. And then it says the maximum amount payable is $15,000, see section 16.3. And there's a regulation that governs that as well. Section 17 is the section that talks about the grant of an indemnity certificate. So basically that's your provisions. So, I mean, it's available, but in very limited sorts of circumstances. It's got to be an error of law by the judge in a civil, basically in a civil matter at first instance. So that'll give you some funds towards the cost of the appeal, but it's only going to be a small amount in the total bill, but it's there. All right. Any questions about the existence of this fund? How it's paid for? We've sort of set that out. All right. So we're going to look at maybe problem 32. Skip ahead one. So this is about security for costs. Plaintiff loses her action and dodges an appeal. Oh, sorry, not dodges, lodges an appeal, and $500 for security for costs of the appeal. So security for costs applies both at trial at lower levels and also in relation to an appeal, and asks, how can a defendant, respondent to the appeal, obtain an increased amount of security for costs? Now, security for costs is a funny sort of creature. I think the biggest amount was in the UK, and it ran into many, many hundreds of millions of dollars. So they can be quite large amounts. So appellate courts, just like their trial courts, can order security for costs. They've got what they call an unfettered discretion. So you will see various judges and courts of appeals set out examples of the types of discretionary factors that they'll take into consideration, but it's an unfettered discretion. So what that means is that basically there's no restrictions on the exercise of their discretion at all. They can take into account whatever they want to. But typical sorts of things would be the appeal is abuse of process or is vexatious. So why should the respondent, so the logic is, why should the respondent to the appeal have to suffer the costs and consequences of the appeal? There should be some way to compensate them if this is a vexatious proceeding or otherwise an abusive process. So they would argue that security for costs should be provided and that money, for example, be paid into court or some sort of security be provided so that if the appeal is ultimately unsuccessful, then they would be compensated from the funds that have been provided for security for costs. They're not left with a situation of having to chase after the applicant appellant for those funds because it's already in court. So if an order is made for costs in their favour, they can get that immediately. It's paid out of court to them. So that's the reason for it. Another example would be an impecunious corporation, if the appellant is an impecunious corporation, or what they call a man of straw. So if you're being sued by an impecunious corporation in an appeal, if you are successfully defend the appeal, it sort of leaves you in a situation where you've spent all of this money and got no way of recovering it because the appellant has got no cash. It's impecunious. Another example is where the appellant is ordinarily resident outside of the jurisdiction. So this is a situation where, because they're outside of the jurisdiction, if you're successful in defending the appeal, it's hard for you to try and recover the costs because they're not within the jurisdiction. There is an exception in that category where there is property, if there's sufficient property within the jurisdiction. So all of those are the main bases or situations where you'd be seeking security for costs. Some of the discretionary factors would be the merits of the appeal. So if it's a really meritorious appeal, then the court is less likely to order security for costs, because if it ordered security for costs and if the appellant didn't have enough financial resources to be able to pay the security, then in effect what the court would be doing would be denying them access to justice, because they can't bring their proceeding unless they provide the security, and they don't have the resources to provide the security. The proceeding can't go ahead. So that's a factor which tends to favour the appellant in not ordering security for costs. If the appellant is an impecunious natural person, so when we say natural, a real person, not a corporation, then if they're impecunious, the same sort of argument. Do you deny a person access to justice because they happen to be poor? You might have barristers and solicitors acting pro bono to bring the appeal. So that's a factor, whether you're denying access to justice. Public interest is another one. Or liberty of the appellant, say they're being fined or detained in some way. Would it be fair to prevent them from bringing their appeal to try and, regain their liberty or avoid a penalty if they can't provide security? Another good example is where the poverty of the appellant arose from the actions of the respondent. So the respondent to the appeal arguably caused the poverty or impecuniosity of the appellant. So if that's the case, it would be pretty harsh to deny the appellant the right to appeal when their very lack of financial resources is caused by the defendant or the appellant. I'm sorry, not the appellant, the respondent, the person who's defending the appeal. So there's a few factors there. Prompt delay, promptness is really important. If you delay in making an application for security for costs, whether at trial or appeal, it doesn't matter. That's a factor which is against making an order. If you fail to pay the costs of first instance, that's another factor against these sorts of orders. So basically what you do is to get one of these orders, you make what is the equivalent of an interlocutory application, except it's at the appeal stage. So you file an application, there's a Form 69 and an affidavit setting out facts involved. And that's how you would proceed to get the sort of judgment. Okay. All right. So that's basically security for costs. I once wrote a book on that many years ago. It's an interesting area. All right. We might actually have to stop because my wife just showed me that we're about to be smashed to pieces by a terrible looking hailstorm. So I might have to stop and cut ourselves off early this week. So I apologise for that.
Just a quick question, sorry.
Yeah, Robert.
Go. What's the expected date for the return of the results on that second assessment?
Now with that, so I talked to the marker today. He's marked 30 of them. He's going to send me copies of samples of the ones he's done so I can have a look at how he's going with that. But I would envisage generally get that back within 2.5 weeks. So what would that be? Probably around about Isn't now the 1st of October, maybe about the 10th. It should be before that, before the actual multi-choice, just before that. Yeah. But I want to have a look at how he's going with the marking, because there's such a wide variety of potential answers to this.
So will the exam be released on the 8th and due on the 12th? I know once you log in, you've got 2 hours, but.
Yes, it's released, I think it's quite late on the 8th. And then you just check the time.
1 a.m. in the morning.
Yeah,
isn't it?
it's really late. So it will be open at the times it's specified, and it closes at the time it's specified at the end. But just be careful. Don't leave it to the last minute, because the way in which it'll just cut you off midstream. So given that I think you've got, 2 hours from memory to actually work on it. And if it's cut off pretty much at midnight, then you want to make sure that you start it at the very latest at 10 o'clock in the evening, because you won't get the full time otherwise. Like, you can't get to the very last second and then start 2 hours. It won't let you do that. The system doesn't cope with that. So you've got flexibility as to when you start it within the dates. Okay. All right. Things are starting to get nasty outside now. Sorry.
It does look like your house is shaking. So
yeah, it's pretty bad. My dog is shaking under here as well, actually.
Oh,
He doesn't like the storms. So I apologise for that. If you've got any questions, look, don't hesitate to contact me. Send me an email. And I'll see you next week.
Hopefully you'll see us next week.
Yeah. Just beware. We've actually been struck by lightning twice, this house. So I'm really conscious of that. We had an blue arc right through the middle of the house once.
Well, you just stay safe.
Tell everybody. Okay. Thanks very much, Helen. Okay. Bye.